and we are here as part of the ongoing compliance webinar series. This installment has to do with EMTALA. It's a topic that has been largely fixed with periodic updates with regard to questions about standing and its application over the several decades, almost 4 decades now, since it was enacted in the 1980s. And it's received new and recent attention over the last year since the U.S. Supreme Court's decision in the Dobbs case. So we'll be talking a little bit about that, but this is just a good reminder about hospitals, both hospitals with emergency departments and also acute hospitals and hospitals without emergency departments, as to their obligations to accept transfers and to treat individuals who present with medical conditions requiring evaluation and stabilization under this federal law. General purpose disclaimer. This is general information. Even if you are a client of Holland & Hart, this is not necessarily legal advice. So if there are specific questions about EMTALA and how it applies to your hospital or your organization as an entity that has to make referrals or accept transfers, that is something that needs to be directed to a specific attorney. And while we think that this is a very detailed and comprehensive presentation that we're making, and there are supporting materials that will be distributed as well, this is no substitute for legal advice about your particular situation, facts, and circumstances. Again, this is an overview of the relevant federal laws. It is not specific to any situation you may have. While we will do questions and answers at the end, if you have questions, please add them to the chat. My plan, however, is to address all of them at the end of the presentation. And when situations arise, again, consult with your specific attorneys. Also be mindful of the state that you're operating in. In addition to the labor question that's affected by the Dobbs decision, you may have specific interpretations of how EMTALA is handled. Across Holland & Hart, our offices are largely split between the 10th Circuit and the 9th Circuit Court of Appeals among the federal courts that will most likely often have interaction with EMTALA, and for that reason there might be nuances as to how the law is applied, how it's interpreted, and to questions of standing as to who has rights to civil enforce the statute, which is a topic we'll talk about later in this presentation. So EMTALA applies to hospitals with emergency departments that are participating in Medicare. These requirements include medical screening exams, stabilizing treatment, and making or receiving appropriate transfers unless there's a diversion in place. Receiving hospitals for transfers have specific requirements. For example, acute care hospitals or other specialty hospitals that don't have emergency departments still have obligations under EMTALA, namely to accept transfers unless they're on a diversionary status. How to handle patients who refuse examination or treatment and attempt to leave without against medical advice and without receiving treatment. The responsibilities of hospitals in providing adequate on-call physicians and making sure it has coverage to provide these kind of emergency services, or as a result of not having adequate coverage to result to diversionary status. The documentation requirements and avoiding penalties, including both civil liability by individual litigants and by the Department of Health and Human Services. The enacting statute for EMTALA is identified here. It's 42 U.S.C. 1395 DD. For those of you who are very deep in this space, it's very similar to the statute for the physician self-referral prohibition statute, commonly known as the Stark Law, which is 42 U.S.C. 1395 NN. So these are all fundamentally payment statutes, meaning that these are the obligations that entities have as a result of receiving payment under the Medicare program. There are also interpretive guidelines that are issued by the State Operations Manual and Appendix 5. It's been revised last in 2019. Further guidance might be coming due to the Dobbs decision, but right now that's governed by letter guidance from CMS that was issued in the wake of the Dobbs decision about the preemption of EMTALA as federal law over individual state laws that might have been triggered as a result of that decision, and we'll be talking more about that later. But these are the authorities that pertain to EMTALA and to how it would apply to your entity and your hospital. Hospitals that participate in Medicare and have a dedicated emergency department have to be licensed as an emergency room and department, held out to the public as a place that provides emergency care without appointment, and provided at least 1/3 of outpatient visits for emergency conditions on an urgent basis without prior appointment. And that's the emergency department that is the threshold for having to basically take all comers, regardless of payment source or ability to pay, for medical screening and evaluation and for providing any kind of stabilizing treatment that's necessary. And then there are also hospitals with specialized capabilities like specialty hospitals and acute care hospitals that don't have emergency departments that also have their EMTALA obligations to accept transfers that we'll be discussing shortly. Physicians that provide these on-call services for the hospitals also have obligations under EMTALA, but these are largely facility-level requirements. The physicians are just the instrumentalities through which these services are provided. Like many federal laws, EMTALA is subject to a host of penalties for violations. These penalties are subject and scaled up every single year to track the rate of inflation. For hospitals with under 100 beds, the violations are potentially measured at an amount of in excess of $54,000. For larger hospitals with 100 beds or more, the penalties for violation of EMTALA exceed $111,000 for violation. Always a difficult number when you see 3 ones in a row. It's reminiscent of The Hobbit and Bilbo Baggins' age. And for physicians, the violations can exceed $1,111 as well. There are other penalties that can be imposed, including termination of the Medicare provider agreement and exclusion from Medicare and Medicaid, which for any hospital is tantamount to the requirement of its closure. Hospitals can also be sued for damages by individual litigants, for people who serve individual personal harm, and medical facilities that suffer financial loss because of the hospital's violation of EMTALA, such as, for example, not accepting transfers or denying care to individuals who show up requiring emergency treatment. Now, during a national emergency, some of these penalties can be suspended. For example, at the very beginning of COVID, when there was the public health emergency that was declared over that, this largely contemplates individual circumstances of war, other exigent circumstances, such as, for example, speaking locally to Las Vegas, the events of October 1st, 2017, when there was a very large mass shooting event. I believe it's still the largest one that happened in American history on American soil, where a gunman opened fire on a country music festival, and I believe every single hospital in Las Vegas was on the receiving end of patients from that. And miraculously, anybody that made it to a hospital survived as a result of all of that. But part of that was because of the disaster response that was implemented by the hospitals, the ability to divert patients to hospitals that had capacity, and the ability to provide treatment with the kind of coordination and diversionary activity that we'll be discussing in this presentation. To comply with EMTALA, a hospital with a dedicated emergency department must provide an emergency medical screening examination, treatment to stabilize the patient's emergency conditions, or appropriate transfer of an unstabilized person if the hospital that is receiving that patient has inadequate resources to provide stabilizing care. Like, for example, this might happen the most often with critical access hospitals or rural hospitals and have the requirement to either do a medical evacuation with a helicopter or to use an ambulance or other service for ground transportation of that individual to a larger general hospital or a hospital with a larger trauma response unit. Hospitals with specialized capabilities have to accept the transfer of an unstabilized person as a requirement of EMTALA, and the examination or treatment that is required to screen a patient that appears at the emergency department and to stabilize them can't be delayed in order to inquire and to investigate the patient's ability to pay. And then there's signage requirements that have to be satisfied. And those signage requirements are also subject to the accessibility requirements that are being implemented from Section 1557 of the Affordable Care Act, which is being increasingly promulgated through rulemaking regarding accessibility and the requirements of that rule so that their signs are posted in different languages and that are understandable to the populations that are likely to actually use that hospital. There are also documentary requirements that have to be satisfied by the hospital, including maintaining an accurate on-call list and a log of individuals who come to the hospital to make sure that those who receive stabilizing treatment receive it and are screened appropriately. For hospitals that do have a dedicated emergency department, EMTALA is triggered if a person comes to the emergency department. That's the statutory language. That is some of the language that is subject to interpretation by courts as to what that means. And we'll be talking about the scope of what it means for a person to come to the emergency department later in this presentation. It's broader than somebody just walking in the door. And that's why it's important to have certain policies and practices in place for the physical location of the hospital, to have security present within the area to make sure that somebody who is on the premises seeking emergency treatment gets to the emergency room in order to make sure that that obligation to provide emergency care is discharged, and there isn't a situation where somebody, whether they're having adverse life circumstances such as being unsheltered or unhoused, or is having psychiatric episodes and is unable to present themselves to the emergency department while nonetheless seeking emergency care is taken in by, is screened by, and providing any necessary stabilizing care or transferred out of that hospital by the emergency department. If hospitals do not have an emergency department, EMTALA is triggered if the hospital participates in Medicare, has specialized capabilities like an orthopedic recovery hospital or other hospitals that specialize in cancer treatment, and receives a request for transfer from another facility, such as one with an emergency department. Notably, backtracking a little bit, EMTALA only applies to people who are coming to the hospital for the first time. If the person is already an inpatient and their condition worsens and they have to be transferred to ICU, that's something that falls within the policies and procedures of the hospital for providing adequate care, but it doesn't separately trigger EMTALA because they're already a patient of a hospital. This deals more with people arriving through ambulances or arriving on their own or coming in off the street. Like we discussed earlier, the issue in construing and coming to the emergency department is one that is subject to judicial interpretation. So the guidance through decisional authority and best practices that has evolved is that looking at the entire main campus of the hospital and determines whether somebody is coming to the emergency room, whether they're on a parking lot and they're on a sidewalk, in a driveway, or somewhere else on the campus. For that reason, this is not somehow, but is often reflected in the design of hospital campuses and other healthcare facilities, looking to an area of 250 yards within the hospital that is owned by the hospital and is something that the hospital would have jurisdiction over, such as part of the broader medical campus, if there is one at that hospital, where there would be care provided, such as a parking lot for other physician offices that are leased or occupied within the medical campus. That is an area where EMTALA might apply if it's within that 250 yards that's owned by the hospital. Now, if it's not owned by the hospital, it's off property, and this is an issue more in denser urban areas where the hospital might be landlocked between other areas, then EMTALA doesn't apply. But for areas that are within the hospital's ownership and within 250 yards of the actual physical location of the hospital, it's important for the hospital and its planning and its administration to contemplate that there's a need to monitor these areas and make sure that there's the ability to have emergency response to get people that might collapse in a parking lot or have a medical event in an elevator, for example, if leaving a medical campus tower that's adjacent to the hospital after some other appointment because they have an adverse reaction, to get that person to the emergency department for the medical screening and stabilizing care. Certain things that are not considered part of the hospital, however, are physician offices, residential home cares, hospices, skilled nursing facilities, or other entities that don't operate under the hospital's provider number. So in that situation, if somebody's at a skilled nursing facility, they're not going to be subject to EMTALA, but there should be some level of coordination to make the discharge from the skilled nursing facility to the hospital itself, even if it's going to be under a different entity number than the hospital, just for this reason that all skilled nursing facilities need to have that ability to make the referral to the hospital for stabilizing treatment of their patients if they have adverse health events. So ambulances and their obligation of EMTALA depend on whether the ambulance service is operated by the hospital or if it's a separate hospital, a separate ambulance administrative entity. EMTALA applies to the hospital if the patient is in the hospital's ambulance, unless the ambulance is operated under a community-wide emergency medical services protocol that directs it to a different hospital, such as a central dispatch for certain ambulance companies that provide services to municipalities and might have contracts or credentials within a county or a state to provide those services, but aren't beholden to a specific hospital. Or if the if the ambulance is already acting at the direction of a physician for a different hospital, in which case that hospital ultimately becomes responsible for directing that ambulance. This is more of an operational question. It has to do with how ambulances are hailed to hospitals and communicate with hospitals to make sure that they are taking a patient to the correct hospital that has the capability to see them. Now, if an ambulance is not owned and operated by the hospital, then EMTALA applies to the hospital if the ambulance is on the hospital property. So once an ambulance arrives, that person has come to the emergency department. But anytime prior to then, the hospital can divert that ambulance to a different emergency department, and there are obligations in order to make that diversion and to document the needs for it in order to comply with federal law that we'll be talking about later. But generally, if the hospital owns the ambulance, then EMTALA is going to apply to it. If it's a community ambulance, it's not going to apply, but the hospital can end up making itself responsible for that. by allowing the ambulance to arrive to the hospital, or providing a kind of guidance or direction to that ambulance as to where it should go en route to that hospital, unless it's being diverted. So diversion is a specific status that has to be declared, and there's criteria for going into diversionary status, and it pertains to having a lack of facilities or staff to accept additional emergency patients. This is something that requires planning around peak holidays where accidents are most common. Two that come to mind immediately are Thanksgiving, where there's the perennial story of people getting severely injured or burning their house down because of trying to fry a turkey in a frying device that has too much oil, and the displacement of the turkey is too large, and then you have hot oil spilling over that can cause significant burns and can even burn down people's houses. Or the 4th of July, which is often when new residents come, and there's another instance where many people, irrespective of the legality of fireworks in that state, end up injuring themselves with fireworks over that holiday. So generally, unless you are already in diversionary status and have provided the documentation and created the internal documentation to support that diversion, and informed ambulances that you are on diversionary status and have to send those ambulances to other emergency departments, once an ambulance is confirmed to be en route, the precedent in the Ninth Circuit, which encompasses the hospitals that are going to be in Idaho and Nevada, among others within our footprint, but not in Colorado or Utah, what will end up happening is in those circumstances, those hospitals likely the ambulances can't be diverted once they're on their way. The diversionary status has to be set up in advance and be communicated to the ambulances, but once somebody's there, and certainly once they're on their property, the hospital is unable to turn away those patients. Now, to enter diversionary status, the capacity is going to depend on staff, equipment, and supplies. This, again, goes to the shortage of supplies that occurred during COVID and likely made the threshold for going on diversionary status lower than it normally would have been, similar to the number and availability of beds. And past practices in accommodating additional patients in excess of occupancy limits, such as moving patients in other units, putting patients in the hallway and calling in additional staff that's on call, or borrowing equipment from other hospitals. Going back to that example from Las Vegas in October of 2017, in those circumstances, if everybody is under the same strain, under the circumstances, it's very difficult for one hospital to go into diversionary status when others are similarly taking on more patients they can accommodate just because of the sheer number of casualties and looking at the number of people that are affected versus the available medical resources. But if there's something very localized, like, for example, if there's a very large accident or some other kind of casualty event in front of or in the proximity of one hospital, then it might make sense for that hospital to say, we only have so much capacity, this is going to take more of our supplies. For example, this is going to take out a significant percentage of our blood bank just to stabilize these patients. We're going on diversionary status. All these other hospitals are not affected by this specific event, and they can continue to see patients and receive them in their emergency department. So it really depends on the circumstances. Again, a significant local emergency that wipes out all of the hospitals, it's harder to go on diversionary status because everyone's bearing the same shortage of resources and supplies and staffing to do it. But where the event is localized, it's a little bit easier to go on diversionary status and be able to document what the shortage is, what supplies are not going to be present, in case that there's any kind of investigation by the Office of the Inspector General or by the Department of Health and Human Services as to why there was that diversionary status and whether it was proper and permissible under the applicable regulations. So specific rules about diversion. Somebody who's not on the hospital property and is not in an ambulance can be diverted. So if there's signs out front, in front of the property, if there's somebody out that's waving traffic on before somebody can come onto hospital property, this is kind of a logistical question that depends on the physical plant and the layout of the hospital, but this can be done, such as by somebody out in front of an area waving people on to say that we can't take any more people at this hospital and providing direction to different hospitals or identifying other hospitals that might be available to provide those services. If a person is in an ambulance, the treatment options and alternative hospitals can be discussed with the ambulance crew, but diversion can be difficult in that moment if the ambulance is on its way, such as, for example, if the hospital has already indicated that it can take that patient, and then in the course of transit, the hospital no longer has that capacity. So it's important to know before accepting any specific patient from an ambulance and when coordinating with the ambulance to know in advance what the capacity is in terms of staffing and supplies and resources before agreeing to accept any kind of patient coming in from an ambulance. Inbound ambulances cannot be diverted unless you're on diversionary status, which requires affirmatively stepping into that status and knowing if it's going to be time limited and what the bases are and being able to document all of that in case of an investigation. If somebody comes to the hospital, like if they walk on or if they come in with an ambulance, once they're on the property, or if they walk through the emergency department doors, then treatment is required, regardless of diversionary status. So using diversionary status requires some degree of playing defense and thinking about what are the avenues where people could be coming to the hospital and finding ways to divert them elsewhere before they come on the property. And regardless of being in diversionary status, their obligations, the hospital's obligation to provide treatment and their right to treatment under EMTALA is going to be triggered. Some hospitals that have helipads have special obligations under EMTALA as well. If the patient is brought to the hospital for examination prior to transport to another facility, EMTALA will apply, and the hospital has to provide a screening examination and stabilizing treatment, and if appropriate, a medical transfer to another facility. If another facility has already examined the person and the hospital's helipad is just used for transportation, though, EMTALA will not apply unless the person's condition has deteriorated or the request is made for examiner treatment by the person who is in the helicopter or elsewhere. So, for example, if the patient has already received stabilizing treatment on hospital A before coming to your hospital with the helipad, then you don't have separate, as the receiving hospital that is going to be used solely for the helipad, there's no separate EMTALA obligation just for the use of the helipad. However, if en route from hospital A the patient's condition deteriorates, then the hospital with the helipad has new obligations triggered by EMTALA to treat and stabilize that patient until they can be transferred onward. And the same works in reverse. If somebody is being transferred from your hospital to a hospital with a helipad, that hospital that's receiving the person just for transportation purposes does not necessarily have obligations under EMTALA, but they can if the patient requests further treatment or if the condition deteriorates. So EMTALA is broad, but it's not limitless. So the treatment that somebody needs in an emergency department if they show up has to be for a medical condition. And there's standards for evaluating that person if they're unable to speak or make verbal communication, and treat what is apparent to a reasonably prudent person. So training is necessary for physicians and nurses to make sure they know what they're looking for and what is apparent to them as they evaluate the patient and go over what they see. If the person presents in the hospital outside of an emergency department, such as on the premises, on a sidewalk, or if they clearly are in need of medical attention, the individual patient can request an examination or treatment for a potential emergency condition, not just any kind of treatment. So if the person is unable to speak, again, a prudent person subject to the training that needs to be given to the individuals that are on the hospital premises that might see these patients and encounter them outside of the emergency department, but who are nonetheless seeking emergency department on the hospital property, they need to be trained to determine whether the person needs an emergency condition. So if that individual is unconscious, unable to speak, or in a state of some kind of distress, such as on the ground, then they would need to get the appropriate means to transport that person into the emergency department, which might require, a headboard or a backboard, for example, depending on the nature and the severity of the apparent injuries. Non-emergency services, however, are not subject to EMTALA. So if somebody comes to an emergency department seeking a vaccine, another immunization, antibiotics, community outreach, like, for example, if they need psychiatric care that's not emergency in nature, a common example in emergency departments are people seeking treatment for sexually transmitted infections. Those are not emergency care. So while the person has come to the emergency room, if they're specifically seeking non-emergency care, then EMTALA doesn't require, and they can be recommended to non-emergency facilities. Evidence can be gathered for other purposes, or they can be sent to a pre-scheduled appointment by a physician. So if somebody's coming to the hospital for scheduled surgery, EMTALA does not apply to them, even if they present in the emergency room. If it's not for something that is emergency care, again, going to the examples about somebody having persistent headaches or something that requires general treatment by a physician, the EMTALA requirements will not abide to them. And the standard for evaluating that is, again, the prudent layperson. So making sure that everybody has everybody on the staff, whether they're the intake medical assistants or if they're doing the triage, if they're nurses or if they're physicians, everybody can evaluate based on this prudent layperson standard, if the standard would be that that person requires emergency care. So the delineation between a stomach ache because of indigestion or potential food poisoning versus severe stomach pains because of the need for an immediate removal of a appendix or other emergency treatment. So there are special rules for infants as well. Remember, the ELAs EMTALA has to do with labor. So for infants, birth constitutes the infant coming to the hospital. If the infant is born alive at the hospital, EMTALA will apply to the infant, making sure that any evaluation and emergency care that's necessary is provided. This requires the hospital to provide an exam, any kind of stabilizing treatment, and an appropriate transfer of the infant if it's going to be necessary. The request for exam or treatment, or the hospital has to provide the exam and stabilizing treatment if there is a request by the parent who is acting for the patient, in that case, due to the laws of most states allowing the parent to act on behalf of the infant who is unable to act on his own or her own. And the prudent person would believe that the infant needs exam or treatment, and that would largely be the delivery physician or delivery nurse or the OBGYN that would be involved in that infant's care from the point of birth. For patients of the hospital, EMTALA does not apply. EMTALA ends once the person is admitted as a patient, and on outpatient for the basis of outpatient procedures, such as a patient that comes to the hospital for a follow-up, or to receive an outpatient procedure such as stitches, sutures, something along those lines, removal of small growths, EMTALA would not apply either if they've been receiving outpatient services other than emergency care. If an emergency arises even after somebody's admission or after the outpatient services begin, EMTALA would not apply. Now, that would be subject to the hospital's policies and procedures to maintain care for the patient, and something might happen, like, for example, if an outpatient procedure goes wrong or there's a bad medical outcome to it, there's an adverse reaction to a drug that's used, then that person would need to be transferred to care the same way that they would if they were an inpatient for that purpose. But that is subject to the hospital's policies and procedures and any applicable state law regarding standards of care, but not EMTALA itself, because that person is already a patient of the hospital. So for hospitals that do have emergency departments, we have a person that comes to the hospital that has an emergency department, requests an emergency exam or treatment, and is now already a patient, whether on an inpatient or outpatient basis. The emergency department has to provide an appropriate medical screening exam to determine whether the person has an emergency medical condition. And if the person has an emergency medical condition, the hospital needs to provide either stabilizing treatment or an appropriate transfer to a different hospital. We have broken this down in this flow chart about what happens, starting with the medical screening exam and different potential outcomes. The first is the screening exam occurs by a competent person applying the appropriate standards of care. If there is no emergency medical condition, then EMTALA is done. The patient can be transferred or discharged, and that will be the end of it. There's no emergency medical condition that needs to be stabilized. The hospital can either say that the patient needs to go elsewhere, and that might be discharged in the community, or be transferred to some other care setting, whether it's a skilled nursing facility, or unfortunately, in some cases, a psychiatric facility. There are regulatory guidances as to what constitutes an appropriate medical screening exam, and it has to be performed by qualified medical personnel. The people who are eligible and qualified to perform these screenings are identified in the bylaws or the policies and practices of the hospital. And they have to be competent to perform the examination. Generally, you will want this to be a registered nurse, an advanced practice registered nurse, or a physician, and privileged or credentialed to perform the examination, so they need to have hospital admitting privileges as well. This would work for any of the medical staff that's in the hospital, and this is just put in to make sure that it's not any physician that can perform the exam. It has to be somebody with some kind of relationship with the hospital, namely admitting privileges. The medical examination has to be performed in a non-discriminatory manner, so it can't differ based on payment status, particularly, or medical condition, race, national origin, or disability. So it has to be a standardized exam where everybody receives the same evaluation to determine if they can receive if an emergency condition exists that requires treatment under EMTALA. And finally, the examination has to be sufficient to allow the medical practitioner to determine with reasonable clinical confidence whether an emergency medical condition exists. And this will depend on the signs and symptoms of the presenting patient and the hospital's capabilities, including the on-call physicians. Again, if there are inadequate physicians that are available to provide these services, then the ability of the hospital to provide that treatment is determined take into account to determine if the patient needs to be transferred or discharged, or if care can even be provided. For example, if somebody needs emergency treatments for trauma that's beyond the hospital's capabilities, and stabilizing treatment can't be provided, then a transfer to a higher level of a trauma center would be necessary. And this will come up often for critical access hospitals and for rural hospitals that have the capabilities for certain stabilization, but not necessarily all the stabilization that needs to be provided, especially in the cases of more significant trauma or injuries. Again, these capabilities are outlined here: the physical space, the supplies and equipment that exists, is their ability to provide surgery. For other hospitals that are more remote, it can be difficult to provide certain services such as ICU care above a certain level. Psychiatry care can be difficult to provide. It can be done in certain ways with telemedicine and telehealth, which has been very useful and kind of a boon to these critical access hospitals and more rural hospitals. And it's still useful to do that, but certain hospitals might not have the ability to provide the kind of psychiatric care if somebody needs psychiatric stabilization, and they have to be transferred elsewhere, whether to a larger hospital with psychiatric resources or to a specialty psychiatric facility. And the level of care that the hospital personnel can provide within the training and scope of their professional licenses, including the members of the on-call roster, is relevant to figure out what the hospital's capabilities are. For example, if there's only one physician on call and there's a sudden surge of individuals that are brought in, that's relevant to the care that can be provided and the examination that can be performed to identify the medical emergency and the ability to treat it. Other guidance indicates that the screening exam is kind of an ongoing process. It's not just an event that has a discrete endpoint. The screening examination starts with a triage and extends beyond that point, and it continues until the patient is stabilized and either admitted to the hospital or transferred or discharged. This examination should normally include obtaining vital signs, relevant medical history if it's not already available at the hospital, documenting a physical exam of the bodily system or the area of the body that's involved in the emergency that's being presented to the emergency department, and any ancillary tests, or including those performed by any available specialists that are necessary to perform this evaluation and make a determination about the emergency condition that exists. And this includes continued monitoring through the episode of care until it's completed. The importance of the medical screening exam is to document what was done by whom and what was observed. As noted in the slide, if it's not in the chart, it didn't happen. So if certain conditions exist, those need to be documented. Similarly, if there is not a medical emergency present, the non-existence of conditions is just as important to document, such as the conduct of an appropriate exam, how it was performed, what was evaluated part of it, the existence or lack of an existence of an emergency condition, whether the patient was in a stable condition or not, and if they were in a stable condition, documentation of that stable condition. If the patient refused care or requested a transfer to the hospital, that needs to be documented as well, so the patient can't come back later and say they were abandoned or dumped by the hospital. Finally, there has to be a certification that the benefits of a transfer outweigh the risks of the transfer, especially for patients that require further stabilization. And this goes back to the points about capabilities and resources that were discussed earlier. If another hospital is more likely to have resources, such as they have more staff, they have a more advanced or more built-out trauma unit, those are things that need to be documented to explain why the transfer is made and it's recommended, because the capabilities of that transferee hospital are greater than that of the transferor hospital. And these are all things that need to be put in the chart of the patient, especially at the time of any kind of discharge or transfer, so that the receiving hospital knows what's been done, but also in case there are questions in the future, the hospital is clear of what happened, when, and for what reasons. There's also regulatory guidance as to what constitutes an emergency medical condition that requires treatment for stabilizing care or transfer under EMTALA. This is defined as a medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain, psychiatric disturbances, and or substance abuse, that in the absence of immediate medical attention could reasonably be expected to result in placing the individual's health in serious jeopardy, serious impairment to bodily functions, or serious dysfunction of any bodily organ or part. For pregnant women having labor contractions, this also falls within the scope of it and is considered a medical emergency. And in that case, the hospital has to consider inadequate time to effect a safe transfer to another hospital before delivery, or a transfer may pose a threat to the health or safety of a woman or unborn child. Now, this has to do more with the timing of contractions and the progress of them, the condition of the pregnant woman when she comes to the hospital. Specifically, if there's time before the delivery occurs, then the appropriately qualified medical staff can determine whether a transfer is possible or appropriate or desirable in those circumstances. If there's not enough time and contractions have been going on for some time and labor is significantly progressed, then the transfer would be more dangerous because the delivery would likely happen in an ambulance or some other ground transportation. There's also a regulatory definition of what constitutes labor, which is the process of childhood beginning with latent or early labor and continuing through delivery of the placenta and the completion of the labor process. Any woman experiencing contractions is presumed to be in labor unless a qualified medical practitioner acting within the scope of the practice, which would likely be any of the OBGYNs on staff and maybe some NPs or PAs with specific training in this area, is certified that a false labor is occurring after a reasonable period of observation. It is something that happens. It's not terribly common, so therefore, generally, labor is going to definitionally qualify as going to be a medical condition that requires emergency stabilization, and there have to be adequate basis for transfer, such as either that false labor or if it's very early labor, and the transfer can be done to a nearby hospital without resulting in potential further harm, not only to the woman giving birth, but to the child as well, which will, as we discussed earlier, be subject to EMTALA. I want to talk very briefly about Dobbs because much has been written about this, and we've had our own series of webinars regarding this issue. The guidance from CMS has been that regardless of any state laws, EMTALA is superior. This has been litigated on a state-by-state basis. As always, if you have specific questions about your facility in your state, contact your legal counsel about that, but this is something that's been the case for almost a year now, so the pathways are relatively, at least on a preliminary basis, secure. There are still pending appeals and actions in front of different courts that will provide better clarity on this. But in other states, what the standard has been is that even when there are trigger laws in place, what will happen is for the purposes of providing complying with EMTALA and providing these emergency medical services, if activity is needed to terminate a pregnancy within the scope of EMTALA, that can be performed, but not outside of it in an out-clinic patient, and then in an outpatient context or outside of the hospital. So without getting too deep into the United States Constitution and topics of federalism that many of us probably haven't had to contend with since high school, the issue is that because the federal government and its laws and regulations supersede state law, to the extent that abortion is necessary to comply with EMTALA and provide this kind of life-saving care that is required, such as in the case of a very late ectopic pregnancy or, as people talk about, to save the life of the mother, in those cases where a medical emergency is present, then the abortion can be performed in compliance with EMTALA in the law in the states where the courts have reached this conclusion without violating state law and without being subject to prosecution under state law. So I'm not personally familiar with any prosecutions that have been threatened or instigated under these laws, but what is happening is for many of the elective outpatient abortions, people are traveling to states that will provide it. And in Nevada, we are already seeing a increased demand for the services of OBGYNs who will perform that service because we don't have, in Nevada at least, we don't have the restrictions or the triggering statutes that kicked into effect in other states such as Texas or Idaho, and that have taken action to make less clear the legal status of performing abortions. So it is a problem that I do not think is terribly common from what I have seen, but it is an important one to be aware of because the law in this area is still not definitively resolved, and there's still some tension until the United States Supreme Court speaks further on it or there's some legislative action. Right now, there's largely guidance been given by the Centers for Medicare and Medicaid Services and the Department of Health and Human Services, but there is not anything yet that is definitively binding, such as the decision of Dobbs or the prior decision of Roe versus Wade. So there are some slides on this topic. It provided a summary of what is involved with them and the status of that general litigation and the legal challenges that are proposed. But when it's time to review policies and procedures, since it's been almost a year since Dobbs, if they haven't been revised already, it's important to go and make sure that everything is up to date and to particularly check the laws of your specific state and if any action has been taken by the state legislature or the federal courts in your jurisdiction. Psychiatric conditions are also subject to EMTALA, as discussed earlier. Suicidal ideation, homicidal thoughts or gestures are also covered because they are considered to be dangerous to the self or other and fall within the scope of a medical emergency. Intoxicated individuals can also be subject to EMTALA, especially if they're unconscious or unable to respond. Certain individuals, whether they're unconscious or in a state of blackout where they aren't aware of what's going on, whether from alcohol or other highly dissociative drugs such as ketamine, their health can be in serious jeopardy and be subject to this protection, especially if they've already injured themselves or have unrecognized trauma as a result of their intoxication or dissociative state. So the medical screening exam for non-emergent conditions is only required to rule out an emergency medical condition based on presenting symptoms. If the nature of the patient's request who is presented to the emergency department makes it clear that the condition is not emergent in nature, the hospital is only required to perform the screening that would be appropriate to determine that the person does not have an emergency medical condition. Where there is an obvious non-emergency situation, the person's statement that they're not seeking emergency care, together with a brief screening canvas by the qualified medical professional would be sufficient to rule out an emergency medical condition. However, as noted before, this has to be documented. So if the patient says that they have a headache, but it's not serious and they just need Advil because they, for whatever reason, came to the hospital rather than they get it their own and they wanted to be safer or take extra precautions, as long as that's documented, that's what the patient said, that's what's recommended in the chart to show that there wasn't an emergent condition in case the patient comes back later and has a misrecollection of the event or contends that there was an emergency and they didn't receive adequate treatment. The medical screening exam reveals that there's no emergency medical condition, then EMTALA ends. The patient can be discharged or transferred, and the determination that there is no emergency medical condition and the basis for that conclusion should be documented within the patient's medical chart to prevent any potential claims or to respond to any investigation by the government regarding those issues. If there is an emergency that's revealed in the screening exam, then the hospital has to either provide stabilizing treatment or an appropriate transfer in the manner we've earlier described. So going back again to this medical screening exam, when there is an emergency medical condition on this lower path, there's the requirement to either provide stabilizing treatment or the appropriate transfer, and we'll be talking about what those look like. Stabilizing treatment is something that is necessary to assure within a reasonable medical probability that no material deterioration of condition will result or occur during the transfer of the facility, or for pregnant women, delivery of the child in the placenta, subject to what we discussed earlier about Dobbs, and an appropriate transfer to another facility after the stabilizing treatment occurred. And then the transfer can mean either a transfer to another facility or a transfer to the community, which is better known as discharge. Once the patient is stabilized and can be admitted on an inpatient basis or transferred elsewhere, that is when EMTALA ends. The regulatory definitions for stability and stabilizing a patient indicate that this criteria for stabilization is satisfied when there's no material deterioration of the condition that's likely within a reasonable medical probability to result or occur during the transfer of the patient, including to another facility or to the community, as a result of the transfer, or for pregnant women, delivery of the child. Under the interpretive guidelines for these regulations, the stabilization means the emergency medical condition is resolved, even though the underlying medical condition may persist. For example, if there's an open fracture, the fracture is not going to be treated right then, but it's been closed, the blood loss has ended, and ideally the person has been either put into a temporary splint or some other kind of restraint to help the curative healing of the bone, or is in a position where they can be transferred to receive the orthopedic services necessary to do that. For psychiatric conditions, the standard is a little bit different. The person needs to be protected and prevented from harming themselves or for others. This might be the use of restraints within the appropriate and permissible CMS guidelines. And in those circumstances, the transfer of a psychiatric patient is particularly important. They can be transported either to a psychiatric hospital or to another psychiatric facility that's appropriate for treating them. But it's important to consider where that transfer is being made just because of the range of amenities that are available at different psychiatric facilities. So some are more appropriate for providing these kind of transfers that will have custodial services and be able to use restraints if that's necessary, versus a setting that's more analogous to a group home where that person can potentially cause harm to themselves or others with relatively little supervision. So the standard for stability for discharge is also defined by regulation as being within a reasonable clinical confidence that the patient has reached a point where their continued care, including any diagnostics or treatment, could be reasonably performed as an outpatient or later as an inpatient, provided the patient is given a plan for appropriate follow-up care as part of the discharge instructions. And this is dealt with by the conditions of participation and the rulemaking that CMS engages in regarding discharge planning for the hospital and the individuals and resources that need to be involved within that process. Again, psychiatric conditions are a little bit different. The patient has to no longer be a threat to themselves or to others, and that can require pharmacological intervention or just some time to cool off if there's something that's causing the psychological disturbance until that person is fit for discharge and has their discharge planning completed, such as to resume taking certain medication, to see their provider if they've had one, or to get in contact with another provider if for some reason they are having that gap in care where they don't have a relationship with a psychiatrist that's necessary to monitor and prescribe anything that might be required for their condition. Again, the main rule is documentation for these services to make sure that if somebody is being discharged because they are stable for the purpose of doing so, that their condition is documented for that purpose, and that there's a record to defend the hospital in litigation or against any kind of investigation by regulators that these standards have been satisfied. Again, and going back to the topic of pregnancy we talked about earlier with respect to when a pregnant woman can be transferred, stabilization occurs when the delivery and the child and the placenta has occurred. If a woman is having contractions, the hospital must deliver the baby or the placenta, or the hospital must perform an appropriate transfer, including discharge back to home. So the appropriate transfer happens after the stabilization or potentially during it, and that's where the false labor or the labor determination comes in based on the qualified medical personnel. Generally, having OB personnel on staff or on call for the hospital at all times is desired to avoid these situations where avoid a situation where transfer would need to be contemplated when somebody is in labor or suffering contractions in order to avoid any kind of problems along those lines. And earlier, like with the evaluation, the criteria for evaluation, the hospital's obligation to provide stabilizing treatment is subject to what is within its capacities and its capabilities. So the physical facilities, the equipment, the personnel that are available, the services it can perform are all relevant to the level of stabilizing treatment that the hospital can provide. Similar to HIPAA, where the standard is what's reasonable relative to the resources and the sophistication and the needs of the entity that's subject to HIPAA, such as a medical provider. Depending on the size and scope and the complexity of it, the hospital standard to provide stabilizing treatment is also defined by its own resources and its own capabilities. So once a patient is stabilized, the hospital can admit that patient to receive services on an inpatient basis, and the patient can be discharged, including a discharge to the community or to home, or transferred to another facility. So here, again, with the stabilizing treatment, it's a slightly different flow chart from the one that we had previously seen, which looked to whether there's a medical emergency. Here, we assume that there is. This is starting from the standpoint of stabilizing treatment. We have this upper path where if the patient is stabilized or admitted, then EMTALA ends. But if the patient is not stabilized, then the options are to continue the stabilizing treatment or to make a transfer to a facility that can provide the stabilization that's necessary. When a patient is not stabilized, the hospital generally cannot transfer or discharge a patient. There are exceptions to this, though. If the person or the person's representative, such as the individual that holds the power of attorney, requests a transfer, then the patient can be transferred to a different facility. Or if the physician certifies in writing, and again, this goes to the need to document everything, that the benefits of transfer outweigh the risks, then transfer is appropriate. However, transfer is the movement outside the hospital at the direction of the hospital personnel, including the discharge. If the person leaves the hospital against medical advice or without permission, that is not going to consider a transfer. And if the individual does that, the documentation of the person leaving against medical advice is even more important, likely consistent with the hospital's policies and procedures that exist for dealing with patients who leave against medical advice. And if the person is moved within the hospital, between the hospital's locations, that's not a transfer. That's movement within the same entity, within the same facility and the same entity that has one unified EIN and likely has the same NPI as well. So it would be the same hospital but different locations. This is common within larger hospitals that have different campuses where different modalities might be needed for stabilizing care, such as a trauma unit that's not equipped to deal with the orthopedic piece of it. It's difficult to think of a circumstance where this would squarely apply, but it's contemplated there so that if somebody is being moved within the hospital to be stabilized, they still haven't been transferred. So if a patient requests transfer, or if the patient's authorized representative requests transfer, the hospital has to inform the patient regarding the patient's rights under EMTALA and the risks of transfer, if any. This is another place where documentation comes in to prove that these admonitions were given to the patient if the patient is requesting a transfer. The patient's transfer request should be in writing, whether by the patient or the patient's authorized representative, and identify the reason for the requested transfer and that the patient has been informed of and is aware of the risks of or the benefits of transfer. This is a situation where if the hospital has forms that exist already and can be completed, that would be helpful. The patient can state what the reason for the transfer is, and then the risks and benefits can be completed by the qualified medical personnel that is involved in this treatment, just to make sure that rather than there being a perfunctory statement where the patient initials say, I've been informed of the risks and the benefits, there's more specificity in a place for that to either be entered in, depending on how robust the EMR is in the emergency department, and the ability to quickly digitize those notes so that there's no question about what they mean and they can be entered faster, or an area for handwriting that in so the doctor or the other personnel that's involved in the discharge can write in what those risks and benefits are so that they're in writing rather than the patient saying, I've been apprised of them. They're documented there. So again, in the event of an investigation or a claim, that information exists and has been immortalized so they can be referred to in the future. Additionally, a physician can direct the transfer of a patient if the physician summarizes the risks, reasons, and benefit of the transfer and states that based on the information that's available, the medical benefits outweigh the risk. It has to be signed by the physician, and it cannot be backdated. It has to be contemporaneous and done at that time. It is not something where the certification or the paperwork for the certification can be completed after the transfer is made. And that's a mechanism to avoid the risk of somebody going back and theoretically making changes, or based on the final disposition or outcome of the patient after a transfer, stating the reasons that justify the transfer, or understating or downplaying any potential risk that occurred if there was an adverse outcome to the patient's treatment at the ultimate facility where the patient was treated. If there's not a physician that's present within the emergency department, only then can qualified medical personnel other than the physician sign the document, but only after consultation with the physician, and the physician has to countersign the approval for transfer in the time that's required by the hospital's bylaws or policies. If there's not a bylaw or policy that deals with this, it should be included, or it can be included in a general policy and procedure or a bylaw that pertains to all requirements for countersignatures by physicians for things that are actions that are directed by physicians but not personally signed off on by the physician at the time that they occur. Transfers of patients have to be appropriate in nature. Specifically, the patient can't be transferred, say, to the community when that's inappropriate. So a transferring hospital has to go through a process of contact the receiving facility, confirming that the receiving facility has available space and personnel that can receive the patient, and that the referring hospital has to send the relevant patient records, the name of the on-call physician who didn't respond, and then any additional records regarding the patient as soon as possible to make sure that the receiving facility is able to receive and continue the treatment and any stabilization that's required for the patient, especially in cases where stabilization is not complete and the receiving facility is an essential part of the patient's treatment, because the receiving facility is the one that has the capability to provide the enhanced stabilization treatment that's necessary, including life support measures. When transfer is necessary, the hospital isn't required to maintain emergency medical transportation. Generally, it's better to call an ambulance or arrange for other ground transportation that is arranged by the hospital. This could be an ambulance. It could be one of the ground transportation companies that exist within your jurisdiction in your service area. There are several that exist in Las Vegas that provide these kind of services. The only real pain point here is when patients want to provide for their own transportation, whether driving themselves, having a friend drive, or using a ride-hailing service such as Uber or Lyft. That can be problematic. If the patient wants to do it, ultimately it's difficult to stop the patient, especially if they're acting against medical advice or they're insisting on it. But it's appropriate to take these safeguards. Number one, documenting the fact that the patient refused to use all the ground services, that they insisted on having their own transportation, and that the patient is accompanied by a friend or a family member, such as having a ride from a parent, a sibling, a spouse, a child, or a close friend that has the definable relationship that the patient can explain to the medical staff at the hospital prior to permitting the patient to go or permitting that kind of transportation without it being against medical advice. And the instructions have to be given, such as going to the other facility, providing the address of the other facility, and if there aren't pre-printed forms with it, for example, printing out the directions that you can get from a Google search or from one of the Apple Maps applications that can be called up on a device, so that there are directions provided, not just as to what the location of the other facility is, but clear step-by-step, turn-by-turn directions as to how to get there from the place where the patient is being discharged. For patients that refuse, whether it's refusing an exam, refusing treatment, or refusing transfer, whether because of psychiatric reasons or for religious reasons or any other reason that they're refusing transfer, such as, for example, not wanting to be responsible for the costs of any emergency treatment, the hospital has to offer the examination, the treatment, or the transfer, has to document that the examination, the treatment, or the transfer was refused by the patient, should also document that the risks and benefits were explained to the patient, the basis for the patient refusing a transfer to another facility, and the hospital should also take reasonable steps to secure written informed refusal. This is where the forms for against medical advice come into play, and if they're customizable, whether through handwriting or if they can be written in through a template where this information can be quickly added to the EMR and printed to be signed physically by the patient, that's very important, as well as instructions or a portion of the form that can be used to document the fact that the patient is refusing to sign the documentation regarding the refusal to sign that they acknowledge that they are acting against medical advice. Patients who refuse care can't coerce people into refusing care or refusing the hospital, such as by informing that they'll have to pay for the care. Things that you and I would likely describe as veiled threats, and making it clear that there would be adverse consequences if they were to leave or if they were to stay, and to say that they would be financially responsible for a lot of money, they might have to file bankruptcy, things of that nature. And similarly, you can't make economic comparisons, such as saying that a patient will receive free care or have a lower obligation to pay for care if they go to another hospital. That might be true, but it can't be said in that context to be seen as perceiving, to be perceived as influencing the patient's care decisions, for the same reason that there are statutory prohibitions on withholding care in order to lower cost for economic purposes. This requires some level of discretion and carefulness in having communications with patients. And while the hospital can honestly answer inquiries, the hospital also has to remind the patient the law entitles them to certain care regardless of their ability to pay. So it becomes difficult where if the patient is asking about, say, for example, whether the hospital is in network with their insurance or what the premiums would be, there may be other hospitals that have more favorable rates. The hospital might be out of network for some reason. Very common in larger areas, more so on the coast and in large cities like Chicago, to the point where even Chicago has seen some action by the FTC on that issue with respect to the matching of the dominant healthcare networks and the health insurance networks in the area that's served by a specific hospital. So the hospital can inform to say, well, we're not in network with your provider, but you're still entitled to care. We have to do this for you. You can inform truthfully in response to a question that, yeah, this other hospital may be able to give you a more competitive rate. You might be in network for that insurance, but it shouldn't influence the care that's being provided, and it's not something the hospital should lead with in terms of the patient's care and bringing it up to the patient before making any kind of care-based decisions. Similarly, the hospital can't delay an examination to inquire about payment, can't discourage the receipt of care in order to inquire about payment, and the ability to be paid. It includes for important imaging like X-rays, MRIs, or anything along those lines that might be needed to stabilize and identify the condition of the patient. It cannot be suggested to the patient they should leave, they should obtain their services elsewhere, or the insurance can't cover treatment. So again, difficult line to cross sometimes when honestly answering the patient's questions about what their insurance covers or doesn't cover, but those are conversations that ultimately need to be patient-led and need to be documented to show that they're patient-led rather than something that can be construed as the hospital trying to discourage the patient from seeking care that might ultimately be uncompensated or compensated at a lower rate than the hospital would like to bill the charges for. The hospital can follow a reasonable registration process, obtaining information about the patient that includes insurance information, but cannot condition the treatment on payment. The hospital can also contact the primary physician or health plan to obtain a history or identify their needs, including what the plan, the patient is on for purposes of billing, but cannot seek pre-authorization or condition any kind of care on pre-authorization. A knowledgeable person can answer questions about payment to the patient, but again, that's answering the patient's questions, not leading with the issues about payment that would potentially discourage the patient from seeking the emergency stabilizing care they need or having to go to another facility, at which time their condition could potentially worsen. So we're at the hour. We're a little bit lower on time, so I'm just going to go over this very quickly. There are special considerations for the hospital's capabilities when transferring to a hospital that's a specialty hospital as opposed to another hospital with an emergency department because there are inadequate resources or ability to provide care to the patient. Proper transfers need to be reported by the recipient hospital. There can be consequences, including sanctions against the hospital that is making an improper transfer, including potentially dumping a patient. Physicians and other personnel that are on call at a hospital have specific responsibilities in providing care under EMTALA and receiving and making transfers. These are documented here as well. These include requirements for having plans for backups and other capabilities. It goes on in some detail. There are community call plans where hospitals can divide responsibilities. This includes during wide-scale emergencies, such as that October 2017 attack that occurred in Las Vegas, and is a good example of that. And that requires some level of hospital coordination, and it is guided by CMS, but not necessarily overseen by it. So that requires some level of coordination between the hospitals to coordinate all of this, or within a hospital network if a hospital company has numerous hospitals with one location to have their own internal plan and then another plan to coordinate with the broader community. The documentation is always very important for the reasons we've discussed, both the signage and then also the documentation within the notes about the care that's provided. And the log of the emergency department to show who showed up and the treatment that they received in addition to the patient notes. Again, record keeping, very important to show that the law was followed. It's not about what happened, it's about what you can prove. And the penalty process for what is done by the regulators in addition to private civil litigation against hospitals for violation of EMTALA. And that goes on talking about different issues that can come up. Again, we're hitting these specific pain points that have resulted in significant sanctions and penalties in the past, such as using private cars for transportation, inbound ambulances that were diverted improperly or at the last minute and potentially endangered patients, and requests for transfer of the patient to make sure that only authorized people are making those approvals of transfer requests based on confirming capacity to serve patients and confirming the capabilities that your hospital would have in order to provide treatment and care to the patients that are going to be transferred to the facility. There's no duty to self-report, but it can be useful in certain circumstances to get ahead of the narrative if there was an area of noncompliance. It's important to immediately respond to suspected violations, taking curative action, including further training, updating policies and procedures, imposing sanctions on employees if appropriate, and any additional training that's necessary. And then we have some commentary at the end about government investigations. Always important to cooperate aggressively, make sure the government has everything you want. They get the full context that your hospital is one that is focused on compliance and wishes to comply with all laws. And it takes action to do so. But unfortunately, it's in a situation where there was an instance of noncompliance, and then ideally, that cooperation and willingness to show the government all of the relevant information can result in a reduced or mitigated penalty. So in short, and in conclusion, you will probably be okay if you establish appropriate policies, follow them, do what's best for the patient, and always document the actions that were taken and the reasons for them. We have additional resources that are available. There should be some in the link that was circulated. We have the PowerPoint slides. There are operation manuals, articles by my colleague Kim Stanger, and my contact information is the end. So thank you for your time as we went through all of this. I haven't seen any questions. If there are any questions, though, please email or respond to any of the emails that were sent promoting this event, or you can email me based on the information that is contained on this final slide. Thank you for your time and attention, and we look forward to speaking with you at future compliance webinars in this series. And thank you, as always, for being present to receive the information that we're transmitting, and we hope it's helpful and benefits you and your company and your practice in moving forward and complying with all applicable laws. And we're happy to answer any specific questions that you have that you transmit to us, and look forward to seeing you at the next one. Thank you.